Ladies and gentlemen, welcome to the Cornett Law Review. My name is Rob Cornett, legal analyst and business professional. Just to give you a little background on myself, I have degrees in business as well as legal studies and paralegal studies. Today we're going to be taking a look at Uber, one company who has seen a lot of controversy in recent times. Anyway, sorry, I was playing the video in the background so I could make sure it was working and streaming correctly. Hey, for anybody who has or has not joined us yet, if you are having an issue hearing me or my sound is too loud, let me know. I got a new microphone and we are just trying to make sure that the sound's going across well. Anyways, let's start just delving in here. Before I start talking about Uber and the issues we're facing, let me take my headphones off here. I was just checking the sound myself. We're going to talk a little bit about some of the controversy around Uber, especially with all the protests / potential riots from drivers who are kind of tired of taking it sitting down from Uber. One of the most controversial topics that we see is misclassification. Is Uber misclassifying drivers? Are they employees or are they independent contractors per the definition of the law? There's a two-edged sword to this. If we make the argument that we're being misclassified, we could be reclassified as employees and make even less money. I think more importantly, we should consider the fact that since Uber uses the terminology independent contractor in its contracts with us drivers, that it becomes a part of the contract. The law becomes a part of the contract in the given jurisdiction. So I think it becomes more of a breach of contract issue, in my personal opinion, more of a breach of contract issue where Uber is breaching his contract with drivers in a multitude of ways. Now, the first thing I want to do, and excuse my eyes as they travel over to my screen so I can make sure everything's working right here, is I want to analyze what the law in my jurisdiction says. Now, I am an independent contractor per contract with Uber in the city of Portland, Oregon. So we're going to take a look at what Oregon law has to say about this. And I think you'll find it interesting. I'm going to do a little screen swap over here so we can start taking a look at what Uber's got going on as far as what the law says about how they classify drivers and such. Give me 1 second here. I'm going to transition over into a new screen. It's gonna show the laws here in Oregon. Now I have a legal research tool I use, and I'm sure you all could find your own version or look for these codes directly online. So let's flip over here, get a real quick start into the conversation of Uber. Now, I am sorry. A few things I want to explain. Nothing on this channel is to be considered legal advice. Seek out an attorney who's licensed and experienced in your jurisdiction if you need legal advice. The second thing is I am an individual with autism, so eye contact, even with the camera, can be difficult at times. But I may have to slow down just so I can organize my thoughts as I'm sharing them with you. So please be patient. And finally, before I delve in here to the state of Oregon's definition of an independent contractor, if you find any of the content here helpful, just please hit the subscribe button below. You'll see it down there somewhere. Can't see it on my screen here. And like the video, share it with your friends. Share it with people you know who are Uber drivers or passengers, because this is also, we're probably going to delve into some of the conversation about passengers' frustrations as well at some point within the Uber of It All series. Now, this is a multi-series connection here on this video. This video is going to be part of our Uber of It All series, but it's also going to be part of a big business series where we take on 3 major companies. We're going to take on Uber, their partner in the rental car industry, Hertz, and Progressive Insurance. A lot of things that I've noticed in recent times dealing with all 3 of these companies that I think I can't be the only person facing. So without further ado, let's transition over into our legal research tool here. Give me 1 second. Now, you should be seeing it on your screen. I'm going to move my mic with me, so I apologize if there's some popping, because I'm going to be facing the screen that actually has the content written on it. In fact, actually, let me bring it over here to the other part of my desk here so I can actually still be looking at the camera. Sorry about that. I'm still very new to the YouTube thing, and I decided to go live rather than recording videos right off the bat because, quite frankly, it records them at the same time, and there's no reason I can't be live. It offers me the most chance of engagement with people. The first thing I'm going to take a look at here, you'll see it. It's highlighted. The first highlight, or I should say the second highlight. Now, this is Oregon Revised Statute 670.600. Its heading is literally independent contractor defined. Now, we're not going to read the first few parts because I think these are self-explanatory. But as used in ORS, see if I can highlight it here. You'll see it, subsection 2 here, where it is highlighted. It says, as used in ORS chapters 316, 656, 657, 671, and 701. This is a lot of different sections that are using this definition. Independent contractor means a person who provides services for remuneration, i.e. money, payment to them, and who, in provision of the services, is free from direction and control over the means and manner of providing the services, subject only to the right of the person whom the services are provided to specify desired results. Results, outcome, kind of, I believe, an interchangeable thing here. But what that's basically saying is that, for instance, for Uber to say you have to accept all rides in order to stay active on our platform and to continue doing business with us, that declining rides could eventually lead to your deactivation or the withholding of information. Stop right there. Recently, they changed the way they present information to drivers. Now they show you what they call upfront fares. But they're still very loose-libbed, or not libbed, that's not the right word, loose in how they present the information because they keep changing the way that they structure pay for drivers. And now they're not really showing a structure. They're just telling you how much they were going to pay you for that and not why that's what they're paying you. Now, to get back on subject here, what the outcome would be that they could say is, that it wouldn't be that they could say you have to service all. That's too broad. They could say that all customers of theirs whom you choose to service and provide ride-sharing services to must be served in a professional, ethical, and moral manner, must be serviced in a timely manner, and must be satisfied with the service at its conclusion. In other words, you pick up customer A. They're going from point A to point B. Point B is 5 miles away. We promised them that you'd be to them and then have them to their destination within, say, 15 minutes. Now, that may be broad in some ways, but there are areas where that control would be limited. You can't control traffic. You can't control available routes to get them there. Sometimes you'll be a few minutes out. Sometimes you might even be late to them. But customer satisfaction would be the outcome that they would mostly be focused on. And simply reaching out to a customer and say, hey, traffic's a little heavy. I'm going to be a few minutes late. You may want to wait indoors so you're not super hot. I'll let you know when I'm there within 2 minutes. Chances are that customer is going to be very happy with their service, especially if you pick them up in a clean vehicle, drive them safely to their destination, and get them there quickly without breaking laws or, like I said, endangering their safety. The customer's rating in the end that they give you, and 4-star, 5-star, 3-star, whatever, that's going to determine their satisfaction. Now, that cannot in its own, if failed by the customer's point of view, be enough to deactivate you as a driver, in my opinion. They would have to weigh the reasons for the low rating, and they'd have to share them with you so that you can make course corrections if necessary. However, Uber, I believe that they control us more than this. And the reason I believe this is because they use a rating system. Now, that they have a rating system based on what the customers tell them or rate you at, but they also have a rating system for when you accept and decline trips and cancel trips. Now, the cancel one, I think that could be included in their right to say something, because that's going to be the overall satisfaction of the customer. You've already accepted it. You promised to provide that customer with exceptional service. You cancel that rating, I think should and could be allowed to be held against you, as far as just either the company deciding to continue services with you or not. However, using it as a method to withhold information in order to get you to accept trips you may not normally accept, that may not be profitable to you, that behavior is a control method I do not believe that the law allows for. However, on the acceptance and declination rate, if you decline trips or accept them, I don't think they should legally be allowed to hold this against you in any way, shape, or form, because when they withhold information because of this, or they penalize you because of not accepting certain trips that may not be profitable to you, they're doing a few things, or at least in my opinion, they're doing a few things. One, they are exercising control over by the manners and means which you provide service, the decisions you make to get that service provided. Two, on the the other side of that spectrum is they're basically price fixing you. They're forcing you to accept non-profitable rides because you don't have enough information to make proper decisions off of. And come on, we have to make money. So we may have to take risks that end up costing us money. Well, those risks should be a little more transparent. This is my belief. Now, as you can see here plainly, control seems to be, and this seems to be in a lot of jurisdictions, control seems to be the main topic when it comes to the difference between an employee and an independent contractor. So now we've looked at what Oregon defines as an independent contractor. We've talked about the rating systems, the constant threats of deactivation. I've been driving for Uber for 5 years. I've experienced it all. There are constant threats for deactivation. There are constant warnings when you decline trips and stuff. There shouldn't be any of this. These are all psychological control tactics. And whether it's physical or psychological control, it is still control by the manners and mean which you do things. If they're affecting your psychological point of view on things, they're affecting your business decisions. They're affecting the means and manner by which you make your decisions. This is, in my opinion, and I believe we'll find supported by not only case precedents, but by the law, the written law, the statutes of this jurisdiction, this control exceeds their authority in the independent contractor and employee definitions, or just independent contractor definitions. This would be something you'd be typically more experienced at seeing from an employer of an employee, or by an employee of an employer, however you want to put it. Sorry, getting a little disorganized in my thoughts here. So we have that. We have bonus structures. You don't normally offer advanced pay or bonuses to independent. Well, bonuses maybe, but they also in the past have advanced through their partnerships, might I add, with different banks and stuff, allowing you to draw up to a certain amount that's automatically paid back every time you cash out on Uber. If you cash out on that card, otherwise you could be left with a negative balance. That one there is so gray that I don't think we'd have a fighting argument on that side. We're going to be stuck with mainly control. And more concerns I hear about from drivers are price fixing, which I don't disagree with. If you take a look at Lyft, their partner, and Uber, well, before this most recent change with upfront pricing, their price per mile and minute was dead on, almost exact to each other. This, whether privately or publicly, is a collusion to hold drivers at a certain price. Drivers should be allowed to set their rates, or at least come to a table where rates can be negotiated. But we're not seeing that. Uber sets the rates and we're not allowed to argue it, pretty much at all. Same with damages to vehicles caused by their passengers. They decide how much they're going to give you to cover that. That's wrong. That is fixing you to a price and fixing you to what you're going to receive to make you whole when damages are created. Now, I do have to say that 9 out of 10 times they give you a lot more than you need, but it only takes that 10th time to bankrupt a person. They should not be deciding what you recover from one of their customers. They are the customer. Uber is the customer, and their customers are clients of Uber. They are not our direct customers. We're providing a service to Uber, plain and simple. And their only say, like I said, should be in the satisfaction outcome by the customer, not by how you get the job done. This could travel over into Uber Eats a bit too, which I tested out here recently. For instance, telling you have to use a hot or cold storage bag, telling you which order to make deliveries in could be considered excessive control, and then deciding your rates for you. I don't know if anybody's ever noticed who does drive for Uber or Uber Eats, but there's not a lot of room for profit, especially on Uber Eats. I mean, they are paying a ridiculously low amount of money. I mean, we're talking less than 50 cents a mile by the time it all breaks down, and that's with the tip from the passenger or customer or whatever the case may be. They shouldn't even be bringing that tip into play. You should be paid a livable wage before tips. Tips are what you earn above and beyond. And this is a problem I've had with Uber for a long time. Don't touch the tips. Not in your preconceived estimated pay to you just tell us exactly what you're going to pay us. The tips are separate. We earn those on our own. And I think when they delve into that, they're giving misinformation that doesn't help drivers. It hurts drivers in their decision making about profitable and non-profitable trips to accept. Another control tactic, basically, a psychological one at that. So moving on here, sorry, I keep looking at my screen. I want to go take a look. Let's take a look at what some of the number one complaints are. Well, no, let's scratch that. Let's do a little case law research into what courts have decided as far as in the state of Oregon, the difference between an independent contractor and employee. So we are going to look into Oregon, and we're going to look into case law here. Now, not everybody's going to have these tools at their disposal, but it's still nice to be able to share it. All right, so we got the state, okay. So I did some research prior to making this video, and I want to share that, but I want to make sure I use the same exact search terms I did. So the search term I used was control over independent contractors. So we're going to see what this brings up here. So there's 456 results. Now, I can't remember which cases I was looking at. I have a feeling that, well, this is a different set of case law than what I brought up earlier. Bear with me one moment here. I use the same search terms, but I'm getting a whole different grouping of this is funny. So I'm going to change the jurisdiction because something's not adding up here. We're just going to remove the Oregon District Court. See what that brings up. Wow, this is weird. Huh. I do apologize. Let's see if this brings up something different. Ah, here we go. Guess apparently I didn't include the S at the end there in my original research. But this is a case of Avanti Press Incorporated versus Employment Department Tax Section. I don't know that this is a 100% match to our case, but we're going to take, or to our current situation with Uber, but we're going to take a look. So in this petition, the petitioner of Avanti Press Incorporated seeks review of a final order of administrative law judge that affirmed the Employment Department's notice of tax assessment issued to Avanti. The ALJ, the administrative law judge, determined that Avanti, a greeting card company, had employed a sales representative, Andre, I can't pronounce that last name, and that Avanti's compensation was therefore subject to unemployment tax, which Avanti had not paid. In its petitions for review, that order, Avanti contends, as it did before the ALJ, that the independent contractor, not an employee, or is not an employee, and that her compensation therefore was not subject to unemployment tax. Now, they did reverse and remand this decision after appeal to the district court. And this is the district, this is the Oregon Appellate Courts. Let's see here. Final order, analysis. On judicial review, Avanti argues that the ALJ misinterpreted the direction and control requirement of Oregon Statute 670.6002A and misapplied the applicable administrative rule. I just showed you this law. So this is spot on with the law that I'm being quoted for the definition of independent contractors. Direction and control test states that an independent contractor must be free from direction and control over the means and manner of providing services to others. The agencies that have adopted this rule will use the following definitions in their interpretation and application of the direction and control test. Means are resources used or needed in performing the services. To be free from direction and control over the means of providing services, an independent contractor must determine which resources to use in order to perform the work, and how to use those resources, depending upon the nature of the business. Examples of the means used in performing services include such things as tools or equipment, labor, devices, plans, materials, licenses, property work, location, and asset, among other things. Manner is the method by which the services are performed. To be free from the direction and control over the manner of providing services, an independent contractor must determine how to perform the work. Depending upon the nature of the business, examples of manners by which services are performed include such things as work schedules, work processes, procedures, among other things. Free from direction and control means the independent contractor is free from the right of another person to control the means or manners by which the independent contractor provides services. If the person for whom services are provided has the right to control the means or manner providing the services, it does not matter whether the person actually exercises the right of control. According to Avanti, the ALJ failed to take into account the nature of the business involved in the service performed, and consequently established an impossibly high threshold by which no sales representative could ever qualify as an independent contractor. The department, in response, defends the ALJ's reasoning and submits that there is nothing absurd about the conclusion that a person who promotes an employer's products at prices and terms dictated by the employer is territorial. Okay, we're going to skip past that. I don't think this case is exactly what we're looking for. Now, it did help us cover in more detail the definition of an independent contractor, and more importantly, the definition of control. So let's take a look at another option we have here. I'm sorry, my phone is vibrating. I thought I set it for do not disturb. And it is also my recording device, so I apologize if you're hearing that on your end. I found several here that I believed would apply. And I'm looking at them now. I'm not finding the ones I had earlier. This is the thing with case law. It's updated regularly, and the same search terms don't always pull up the same cases, apparently. But I want to look at Swift couriers here. I think that is one. Administrative law, independent contractors, facts, background. We state the facts consistently with all the unchallenged factual findings of the uncontroverted evidence on the record. Okay, here we go. This is one where the appellate courts of Oregon actually agreed with the administrative law judge in the finding that a company had been treating an independent contractor as an employee. So let's read into this a bit. So Swift Couriers Incorporated petitioned for a review of final order of an administrative law judge that affirmed employment tax assessments by respondent employment department, the department further referred to as. In that order, the ALJ concluded that Swift failed to show that laylock is a person or entity who contracted with Swift as an independent contractor. That Laylock, who worked in Swift's distribution center and provided delivery service for Swift, was an independent contractor, as Swift claimed. Specifically, the ALJ determined that although Swift showed that Laylock was free from Swift's direction and control within the meaning of ORS 670.600, Swift failed to demonstrate that Laylock was customarily engaged in independently established business. Accordingly, the ALJ concluded that Laylock was presumed to be Swift's employee under ORS 657.040 and was not an independent contractor. Before us, Swift challenges the customarily engaged in and independently established business determinations. The department, in a cross-assignment of error, challenges the free from direction and control determination on review for legal error. We agree with the department's argument in the cross-assignment, and for that reason, affirm. Affirm meaning that they're upholding the ALJ's position as to the fact that this person was an employee and not an independent contractor. We state the facts consistently with the ALJ's unchallenged factual findings and uncontroverted evidence in the record. I'm not going to read all this subtitling for you. Swift is a courier and a broker of courier services. Swift delivers and brokers the delivery of different types of packages. The most substantial share of its business involves delivering and brokeraging the delivery of pharmaceuticals. I did not know that. We learned something new today. Now, I could give you a bunch of case background on this, but then I feel like I'm just going to be reading verbatim something off something else, and I want to have a chance to actually comment on this. So what we're going to do is we are going to maintains a business location. So a lot of this has to do with things like business location and that kind of stuff, which is also important. You have to maintain a business location in an independent business in order to be considered an independent contractor. They did actually conclude that Swift did allow Laylock to be free from control and direction. So this once again does not apply to our case. I'm so sorry. We had all this lined out. Like I said, I had a power surge earlier and it reset everything. So all the work I did gone. Mental note to self: learn to save your documents. But I did have, let's take a look at this. This is the second one on our list. And see, this one's a little bit different. This also happened in the appellate court, but the way it's typed up. Okay, so Senior Assistant Attorney General argued the cause for the respondent, with her on the brief where John R. Kroger, Attorney General, and Anna M. Joyce, Solicitor General. Petitioner, as one of the personal representatives of the estate of Alan James, the estate, further referred to as the estate, challenges a tax assessment levied by the tax section of the Oregon Employment Department. The department found that the estate was liable for unemployment insurance taxes based on payments to Gabaldon, Gabaldon? I hope I got that right, who was providing bookkeeping and related services. The estate, valued over $110 million, challenged the assessment, $379.16, arguing that Gabaldon was an independent contractor and that therefore payments for her services did not subject the estate to liability for unemployment insurance taxes. An administrative law judge for the department issued a final order concluding that Gabaldon was the estate's employee and affirming the department's tax assessment. The estate now appeals that order, and we affirm. So here's another one where they affirm, and I think that this may come down, if we read a little bit further, to direction and control, more as it applies to Uber, as far as we could use this to apply to Uber's behaviors, I think. Let's read on a little bit more. We state the facts consistently with the ALJ's unchallenged factual findings. Gabaldon worked as a full-time employee for Alan James for some time until his death in 2005. She was then hired by the estate to help attend to various matters related to the administration of his estate and to the 16 testamentary trusts that James had established. She helped the estate's representatives prepare for the probate case, helped gather information related to the IRS tax case, acted as liaison to the beneficiaries and trustees, and performed other day-to-day bookkeeping tasks. The estate's attorney trained Gabaldon on how to gather information needed for filing probate inventories and accountings. By 2009, Gabaldon had grown familiar with the requirements of her new job and had obtained a paralegal certificate and required less supervision than when she started. So there's some information we can take from this right there. I mean, the fact that she was trained by the estate's attorney, that is direction and control. Right there, plain and simple. Telling you how to do your job. Direction and control. This is an employee. They got this right. So I'm going to scroll down here. And we go right back into the explanation of direction and control. Now, this is basically the final finding. I'm going to read this because this is the important part. The following undisputed facts established that the department did not error, E-R-R, but it's error in its decision. The estate provided Gabaldon with the file cabinets and the external backup computer and drive, battery backup for storing and backing up estate or trust files, and it also reimbursed her for cell phone use, a post office box, postage, copy and mileage, and such office supplies as paper, folders, ink, toner, and storage boxes. It also reimbursed her for out-of-pocket expenses incurred in providing services under possession of those resources upon termination of the agreement. Coupled with its right to terminate the agreement, amount to control of them, the estate also maintained control and direction as to the work location. This is important. For Uber drivers, this means where I pick up and drop off passengers. They control that with their rating system that punishes us if we don't accept all rides by withholding information related to the pickup and drop-off locations. How this has not been contended in court is beyond me, but we'll get into that shortly. Anyways, moving on, by requiring her to work from Portland and by specifying how, if she were to work from a room in her home, that room could be used. If the business location in Gabaldon's residence, she will use it primarily for the business of providing booking and administrative services to others, including but not limited to the personal representation of the estate. Finally, all of Gabaldon's tasks were continuation of tasks that she learned to perform under the direction of the estate while she was clearly a full-time employee. So, for any of you who have been Uber drivers in the past, you know exactly how this feels and what this looks like. When they withhold information from you about pickup and drop-off locations, they are controlling where you do business at and from where you conduct your business. This doesn't just mean your car. This means a geographical location. It doesn't really leave room for a constantly moving office. So when we get into the talk about whether or not Uber is controlling the process of completing the business on behalf of Uber with its clients, they do, through their rating systems, through their withholding of information about locations, and through their retaliatory behavior when you don't accept trips that aren't profitable to you, but that retaliatory behavior being the rating system that starts withholding information from you if you decline trips. Now, Uber recently moved into an upfront pricing scheme with drivers, and we can already see where they're not paying enough right off the bat. It actually exposes it more. And with that extra exposure, and here, let me switch back to our main purview here. So we're kind of done reviewing the law here. With that and a level of control, we're not making the business decisions about how to get the job done. They are. And it's up to us to decide the tools we use and the processes we use to achieve the final outcome that Uber wants. And Uber can't be broad in this outcome either. You know, they can't say you have to service every single person. They can't force you to accept trips that aren't profitable. That is, in its own, I believe, falls under the laws that involve price fixing. Now, I'm not going to get into price fixing this time around. That's going to be a whole nother discussion because that involves a whole nother area of law and actually different agencies. Price fixing. Here, let's go look up the definition of price fixing. Give me 1 second here. Sorry, one of my screens disappeared, and I'm just trying to find it. Oh, it did disappear completely. Well, here, we're just going to change. That'll work. All right, let's look up the definition of price fixing for just a second here. And this is just generalized. We're just looking at what we could find on Google. The meaning, the maintaining of prices at a certain level by agreement between competing sellers. Now, we can't necessarily prove this, but before this recent change to Uber's system and the way they display information to drivers, they were showing a price bracket identical to Lyft as far as pay per mile, pay per minute. We may not have to prove anything in the background. This in itself could be enough proof. It just depends on how it plays out in court, to be honest with you. Now, price fixing falls under FTC or Federal Trade Commission laws. That's why it's a whole nother ballgame, a whole nother discussion that we are not going to get into today. With that said, let's move back over here. There is so much that can be discussed about Uber, and the biggest complaints that I see involves the pay and the treatment of drivers, whether or not they are truly independent contractors or not. Now, in the beginning of this video, I had discussed a few things, or at least I think I did, but I'd like to touch back on those. If we as drivers go out and we challenge a misclassification being classifying us as independent contractors when we're truly treated like employees, that would be considered a misclassification. Now, that involves federal and state laws that do not benefit drivers, in my opinion. If we force them to reclassify, yes, we could gain benefits and all that, but then they could really reduce our pay down. And, well, maybe not so much reduce our pay, but they could exert even more control over us and therefore increasing our expense to do business. But on the flip side of that, they may be responsible for every mile we put on a personal car too to drive as employees separately from the employee part of things. So that touches on a lot of areas. I think the better argument, in my opinion, the better argument for drivers would be that since Uber includes the terms independent contractor in their contracts with drivers, that for them to violate the legal definition of independent contractor would be a breach of contract. I think us as Uber drivers need to come together in one very massive class action lawsuit, probably by district, meaning by state, and file suits in a class action civil case for breach of contract. I think we would win and fare out a lot better than trying to force them to reclassify as employees, because if we can prove breach of contract, we could say, well, they owe us money to cover both the expenses and to make sure we make a fair profit for the vehicle, also to cover the expenses and make sure we make a fair profit for the driver, the person, the individual labor, separate from the mechanical labor, and that those profits should be enough that we can supply all the same things they'd be supplying to us if we were employees. It's just simply not possible. Basically, we could sue them for breach of contract and say we have a right to come to the negotiating table, both for price and to enforce the law upon them as far as treating us like independent contractors. Can all be done in court and public opinion, and should be done in both, in my personal opinion. Now, with that said, we have been recording for 43 minutes now. This first video of mine may not be hyped up to be the best it is, or could be. For viewing, I'm learning, so bear with me. It's a slower process for me, being somebody with autism, but I am trying to provide content that I believe is beneficial. I will leave, however, as crazy as this sounds, I recently wrote a speech, or at least something I wanted to say to you guys. And bear with me, my eye's going to leave to my screen. I don't currently have a teleprompter. I'm working on that. But I just want to read this because I put a lot of thought into this, and I didn't want it to be something simple. So far, if you like the information I shared with you, at least the information, maybe my personality needs a little work. We're going to work on that and get me a little more comfortable in front of the camera. But if the information, if you found that to be a good source of information, please hit the subscribe button, like the video, share it, ask questions. The chat will remain open. I am going to check on this chat window for this specific video and series on a regular basis, and I will respond. You put a big old question mark at the beginning of your chat, or a big old Q at the beginning of your chat, so I know it's a question. I'll do my best to answer them as best I can, and providing as well as not just verbally or by text, but I may do another video. You may have asked me a question that sparks a whole new video, and then you could really get some information that helps you. So please subscribe and help me out. Give me a chance to earn your patronage as a viewer of my YouTube channel. So with that said, I'd like to just read this to you real brief here. I'll try to make it quick, and it may be a little bit jumbled up. But this was supposed to be the initial beginning of this video, and I still want to say it because I'm kind of a history buff, and I can be poetic about law and justice. So this is the first video in my series. Now, I was originally going to call it When Big Business Strikes, but right now we're just into Uber, and we're going to be focusing on Uber. We will be discussing in the actual When Big Business Strikes series. This video will be added to it, but we will be discussing businesses that are or may be under public scrutiny for their business practices. I'm going to start this series with one of those more controversial businesses that we hear of in the news and on social media news outlets. I chose this particular company because there are so many legal topics that can be discussed regarding this particular technology and gig app era company. So without further ado, this was the beginning of my speech. We were going to move into the discussion of Uber. A majority of very public complaints I hear from drivers and customers of the platform involve being charged surprise rates when the trip ends, extremely low pay and misclassification of drivers. Now, I've already shared with you evidence as far as what the law says, and talk to you about what evidence exists, which I could pull up pictures, and if anybody ever requests it, I'll gladly share some pictures of my actual driver app, which I took screenshots of as evidence in this matter. I've got to relocate those because of, as previously described, we had a power surge that shut everything down. But today, we're once again facing the fact that big business is exploiting the American workforce. Since the birth of the United States, the American workforce has been in a constant battle for their rights to be treated fairly, ethically, morally, and to be provided with fair compensation and a livable wage for their labors. With each new era, workers are forced to fight for the same rights over and over again, which signals a troubling, consistent failure of our government to be one of the people, by the people, and for the people. It is time for the failures to be addressed and to come to an end. It is the responsibility of our government body to do the people's bidding. However, more often than not, this body of government, of our nation's government, tends to be more self-serving and concerned more with protecting lobbyist power. The only way to rein in this self-serving body is to unite and stand together once again. Tell our government that big business should never be allowed to exploit our laborers or the public at large. This is a call to action, but please don't confuse this action with violent protest, rioting, or any form of violent behavior. Utilize the healthy tools we have at our disposal. Tools such as the ability to sue for peace, to peacefully protest, and the right to petition with one loud and united voice. Use the arts of humanity to be heard and to effect change. Only when we denounce violence and welcome healthy and respectful debate can we truly come to a lasting and productive outcome that respects the rights of all people. Lastly, we will be covering a lot of legal information that is publicly available. However, as I said in the beginning of this video, nothing discussed in our videos is to be considered legal advice. If you need legal advice, seek out an experienced and state bar licensed attorney. With that said, I'm going to leave and end the video here, give you something to think about. Please go ahead and comment. Offer me suggestions on how I can better provide content and better perform for you as my viewers. Definitely subscribe and like if you found any portion of this helpful. And come enjoy this journey with me as I attempt to become a productive and articulate YouTube channel, or I should say YouTube content creator on my YouTube channel. Anyways, this is Rob Cornett with the Cornett Law Review signing off. Have a wonderful day.